Testing. Calling to order the Cuyahoga County Council regular meeting for Tuesday, April the 24th, 2018. Clerk, would you please call the roll?
Calling the roll, Mr. Schron.
Here.
Ms. Conwell.
Here.
Mr. Jones.
Here.
Ms. Brown.
Present.
Mr. Hauser.
Here.
Ms. Simon. Ms. Baker.
Here.
Mr. Miller.
Here.
Mr. Tuma.
Here.
Mr. Gallagher.
Here.
And Council President Brady.
Here.
There is a quorum.
Pledge allegiance.
Pledge allegiance.
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Under silent meditation, I believe Councilman Schron wants to speak.
Thank you, Mr. President. I think that we lost a great person who was both a public servant and the universal, I believe, grandmother to the nation out there in the form of Ms. Barbara Bush as president, the mother of a president and husband and wife of a president of the United States. That only happened one other time in our history of the United States. And so with that, I would ask for a moment of silence in remembrance of her. Thank you, President Brady.
Thank you, Councilman. Not since Mrs. Adams. Right? Not since Mrs. Adams.
I think it was.
All right, public comment.
Yes, Mr. President, we have three persons who wish to address council. The first is Bernie Moreno.
Welcome.
Turn me on there? Okay, thank you. Well, thank you for allowing me to speak. I appreciate that very much. I want to applaud Council for putting together this Consumer Affairs Board. I think it's a very, very overdue piece. As all of us know who are in the community involved doing nonprofit work, unfortunately, there's a lot of businesses that make a lot of money profiting on the despair of others. I was here present for the conversation about the exemption for new car dealers. Is full disclosure, I am a franchise new car dealer. Less so these days. I had 17 dealerships. I've sold 12 of them, so I have less than I had before. But this is not about carving out a special interest group or treating new car dealers differently. This is about me as a citizen of Cuyahoga County, taxpayer, imploring you that you look at this from a good government perspective. There's a system that the new car dealers have through AutoCap and the Attorney General's office that is extremely efficient. I heard the testimony that they're overworked, that they push papers. I can tell you firsthand that's not true. The reason I know that very well is because I recently purchased a Nissan dealership that I think set the all-time record for most Attorney General complaints from the previous owner. Make sure that's clear. And the deal could not close until we cleared out all those complaints. The Attorney General's office would not allow that to happen, for the deal to happen. And they went through and customer by customer made certain not only that the deals were resolved, but then followed up with the consumers to make sure that everything got taken care of. So my point to all of you is, again, applaud you for setting this up. I think it's great. There's already a system that works really well for car dealers, but I'd like to see the resources, because you don't have unlimited resources, unfortunately. You're going to have a lot of people that hopefully, as they hear about these issues that they have with businesses, that they then come to this commission that you set up. But I'd like to see the commission focus on where there's not somebody there to help others. Mrs. Simon mentioned that she's an attorney. You don't need this for attorneys, because if you have a complaint with an attorney, you go to the Bar Association. You wouldn't go to the county to make a complaint about an attorney. You wouldn't do that with a doctor, because there's already the medical board that exists for that. So the AutoCap process works really, really well. I think taking a look at that and saying, let's set the new car dealers go through that process that exists today, and then you always have the opportunity to be, and I think somebody said it, the safety net to go back. Again, this isn't about treating car dealers any differently. I'm not sitting here advocating for that at all. It's about making certain that this program that you're setting up, that you realize how important this could be and that you have the resources in the right place to fight the right battles. So I appreciate the time. Thank you, all of you, for listening to me for the last 2 minutes, and I hope my comments were helpful for you.
Thank you very much.
Okay, thank you.
Any other public comments?
Yes, Mr. Lou Vitantonio?
Good evening. I appreciate the time. My name is Lou Vitantonio. I'm the president of the Greater Cleveland Auto Dealers Association. I've been a Cuyahoga County resident all my life. John Carroll, all the different things that, great things that we can do here in the county. We represent 283 franchised new car dealers in 21 counties. All of the franchise dealers in Cuyahoga County, there's 77. And we have run the auto cap program, which has been mentioned in the work sessions, through the AG's office for well before I was involved in the association. And back to Bill Brown's administration, Celebrezze, Fisher, Montgomery, Petro, Dan, Rogers, Cordray, and DeWine have all adopted and continued this memorandum of understanding that's in place. We are looking to continue that, and this is a situation where you guys are looking for some authority. I know that it's been mentioned numerous times that we are not the target of this legislation, and we have something that works at this point. We're requesting that the complaints that are coming in be first forwarded through the AutoCap plan or the program. The AG's office doesn't just look at the paperwork and then shuffle paperwork. They have the absolute right to hold any complaints that are put in on new car dealers that are a part of the AutoCap program. They have done that, and they'll hold it back. There's an AG's office locally here that has enforced immediately, and I've been involved in cases that have come in 2 days with a subpoena from the AG's office in Cleveland to a car dealer in Cuyahoga County, and that is lightning fast. Again, we have something that's in place that has worked for a number of years. We are certainly open to having, if the consumers and people of Cuyahoga County are not satisfied with the AutoCap process, we're certainly open to having them come back to the county and the county having the full weight of the AG's, the Consumer Sales Practices Act provisions, and shame on them and shame on our members. But we want to make sure that the program that's in place is continued. And I appreciate the opportunity for the discussion. Any questions that you have, we'll certainly answer them. Thank you.
Thank you very much.
And finally, Ms. Lou?
Good evening. I know definitely for my status, definitely I should not have anything to do with any new cars. Don't even mention car dealership. However, this is a parallel situation to other things we have having in the county. Now, for homeless shelter having problem, for people having custody issue, foster care system problems, whom would they come to get ultimate help? Here, the county government, the capable people elected by all the constituents, taxpayers in this county. Same thing, car problem probably will be the same. Some car dealerships are great, they do honest job, some of them don't. Just like we have a frontline service and we have it with a Catholic center. Same situation. However, for all other problems we have been encountering throughout all the meetings we have here since March, we know lots of problems have been accumulated for a long time. You have heard all those ladies coming here telling you about their difficulties with their children taken away from them. For example, those people's cases already probably started. The situation already started before you guys all got here. However, let me tell you a true story. Currently, right now, we are still in April, so Frontline Service is still in charge of that shelter on Payne Avenue. So I can tell you, there's one worker at the shelter. Her mother passed away when she was young, so she and her 3 siblings were sent to foster care systems. When she was about 14, 15 years old, there was one day when she went back to the place she had to call home at that time. Guess what? She was given flimsy lingerie, sexy lingerie thing, and pushed into the room with an old guy there. That person, of course, wanted to touch her. She struggled. She did not know what was happening at that time, but she struggled and she broke out the window to escape. She is at her 40s, going to be 50s in a few years. So our systems, lots of components, have not been solidly checked, have not been examined to see the flaws and to correct them. In this case, anything we can do now to reverse the damage will be very good, because lots of things were not set up by the people using the services. That's why they did not know the system may not work well. And that's why these entities are not accountable. So having one more layer to protect people in this county is crucial. And I'm glad you are the heroes here, even without masks or capes, but you are the true heroes in people's life. Thank you.
Thank you. All right. You can say that anytime you want to. Anybody else?
No, Mr. President.
Okay, all right. Okay. Under item 6, could I have a motion to approve the minutes as printed in the agenda? Second, moved and seconded to approve the minutes of the April 10th Committee of the Whole and the April 10th regular meeting. Any discussion? All those in favor say aye. Aye. All those opposed? Hearing none, the minutes are approved. Message from the county executive.
Yes, thank you, Mr. President. Tonight, I'd like to use my time to urge council to support the consumer affairs legislation that's coming up for a vote. This legislation is intended to give the County Department of Consumer Affairs the tools it needs to protect our residents from scams and deceptive acts. It also protects businesses from being undercut by rivals that don't play fair. This legislation mirrors the state's Consumer Sales Practices Act. It does not require businesses to do any more than they are already required to do under state law. What this does do is give the county the tools needed to enforce these consumer protections. After we introduced this ordinance, some concerns were raised by businesses. Council has responded with some very reasonable and thoughtful changes to the ordinance. First, a concern was raised about giving enforcement power to an appointed director when the state law assigns the responsibility to an elected attorney general. So the ordinance has been changed to assign that responsibility to the executive. Second, a concern was raised about so-called double jeopardy. So the ordinance was changed to say that if the attorney general has taken on a matter, then the county cannot take on that same matter. Third, a concern was raised about the statute of limitations, so the ordinance was changed to adopt the same rule as under state law. And four, a concern was raised that a business might be penalized for making a good faith mistake, so the ordinance was changed to make it clear that could not occur. These changes are all reasonable and acceptable to the administration, and we ask for your support. Thank you.
Thank you very much. We are going to go out of order now because we have an urgent matter. It's quite unusual, but if you want to refer to page 5 of your agenda, you'll see item 2018-0084. Is that right, Madam Clerk?
Yes, Mr. President.
And we are on a very unusual time crunch that will be explained. But first of all, would you please read the legislation?
Yes, reading into the record, resolution number 2018-0084, making an award on requisition number 42445 to a supplier to be determined in the amount estimated not to exceed $3,922,000 for electric power services for various county buildings for the period May 1, 2018 through April 30, 2021.
Motion to adopt?
Second.
Okay, Mr. President, I'm sorry.
Yes, Councilman.
Do we need a rule suspension?
Yes.
Yes, Councilman, would you like to make that motion?
I so move.
Second.
Favor of suspending the rules, say yes. Yes,
Aye.
rules are suspended. Thank
Okay.
you.
Okay, motion to adopt. And Mr. President, Director of Public Works came before our committee this past Wednesday and explained that this legislation needed to be amended at the actual council meeting, or actually passed at the council meeting early on, because we were up against a time crunch to lock in rates for the energy. This is the lowest and best bidder. We didn't know at the time of the meeting which company would be. And this is Dynegy Energy Services East LLC was the company that came out in this resolution here. So I would ask my colleagues to move forward with supporting this legislation so that we can get this signed and sent off to Dynegy Energy Services prior to 5:30. So we can lock in those rates, because it's basically on this date that we have to lock the rates.
Councilman, it's my understanding there is no substitute legislation, right?
That's correct.
And it's, it is unusual, but we are literally trying to lock in the rates, as late as possible so we get the best rate. So that's where we're at, and I understand the papers need to be signed in about 10 minutes. So,
This is the substitute that you were introducing, was it not, Councilman? To award it to.
I'm sorry,
vendor?
I'm
well,
sorry.
yeah, the
Mr.
substitute
President.
has to have the person who
Yes.
it was awarded to, excuse me.
Yes, so
Right,
you're
right.
making the motion of first, and you need a second?
Okay, so I am making a motion to accept proposed substitute 2018-0084 resolution.
Second.
And moved and seconded. All those in favor of accepting the proposed substitute, say aye.
Aye.
Aye. All those opposed, ayes have it. The substitute is passed. Any discussion on the legislation? All those in favor of passing, in favor of adopting the resolution on its merits as substituted, please say aye.
Aye.
Aye. The ayes have it. The legislation is adopted, and so we need to get that signed. All right. Everybody okay now?
Okay, thank you.
There's a little jujitsu involved in that one. By council, committee reports and consideration of a resolution of council for second reading, adoption, or suspension of the rules. Could I have a motion to suspend the rules?
Move to suspend the rules.
Second.
And second, any discussion? All those in favor say aye. Aye. All those opposed, the ayes have it. Rules have been suspended. Clerk?
Thank you. Resolution number 2018-0079, adopting various changes to the Cuyahoga County non-bargaining classification plan.
Move to adopt. Mr. Chair, Council President, this legislation updates the county's class plan. The legislation revised 7 classifications, created 6 new classifications, and deleted 10 old classifications throughout various departments in the county. This legislation was heard in committee, and I respectfully request my colleagues' support.
Thank you. Any discussion? All those in favor say aye. Aye. All those opposed? The ayes have it. The resolution is adopted. Thank you, Councilwoman. Consideration of ordinances of council for first reading and referral to committee.
Ordinance number 2018-0005, amending Title VII of the Cuyahoga County Code to clarify requirements regarding the use of casino tax revenue and update programs funded by such revenue. Additionally, Councilmember Miller has requested to be a co-sponsor to this legislation.
Thank you. We'll be referring this to the Community Development Committee.
Ordinance number 2018-0006, amending Section 804.01C2 of the Cuyahoga County Code to increase the maximum amount of individual one-year renewable scholarships from $1,500 to $1,750.
Be referring this to the Education Committee. Legislation introduced by the executive, consideration of a resolution for first reading adoption under suspension of rules. Could I have a motion to suspend the rules?
Mr. President, I move to suspend the rules.
Second.
Been moved and seconded. Any discussion? All those in favor say aye.
Aye.
Any nays? The ayes have it. The rules are suspended.
Resolution number 2018-0088, amending the 2018-2019 biennial operating budget for 2018 by providing for additional fiscal appropriations for appropriation transfers and for cash transfers.
Move to adopt.
Been moved and seconded.
And Mr. President and my colleagues, I would start by moving a substitute. The substitute is at the request of the administration. The juvenile court requested additional time to work out the details on the closeout of a number of grants that were part of this resolution. So in the substitute, those items are deleted.
Okay, any discussion? All those in favor of,
Excuse me, Mr. President, you need a second on that motion?
second? Any further discussion? All those in favor of the proposed substitute say aye. Aye. All
Aye.
those opposed, the ayes have it. The proposed substitute is passed. All those in favor of adopting the resolution on its merits as substituted, say aye. Aye.
Aye.
All those opposed, resolution is adopted. Consideration of resolutions for first reading and referral to committee.
Resolution number 2018-0089, authorizing an agreement with and various payments to Dana Green for the purchase of property located at 430 Richmond Road, Richmond Heights, permanent parcel number 662-22013, in connection with the Cuyahoga County Airport Master Plan for various items as printed on the agenda.
Refer to Public Works.
Resolution number 2018-0090, making an award on requisition number 41759 to Nerone and Sons Incorporated in the amount not to exceed $1,915,278.25 for the Broad Rock Court Sanitary Relief Sewer connection in the city of Parma.
We'll refer this to Public Works.
Resolution number 2018-0091, making an award on requisition number 41397 to the Great Lakes Construction Company in the amount not to exceed $3,561,561.58 for the Towpath Trail Stage 1 from Harvard Avenue Trailhead to Steelyard Commons in the city of Cleveland and village of Cuyahoga Heights.
Public Works.
Resolution number 2018-0092, making an award on requisition number 42093 to Bechter Construction Company in the amount not to exceed $686,326.80 for rehabilitation of West 41st Street Bridge number 01.05 over Norfolk Southern Railway and Train Avenue in the city of Cleveland, authorizing the county engineer on behalf of the county executive to make application for allocation from county motor vehicle $7.50 license tax funds in the amount of $586,326.80 to fund said contract.
And this will also be referred to Public Works. Committee report and consideration of a resolution for second reading.
Resolution number 2018-0081, authorizing a lease purchase agreement with Riverbed West in the amount of $25 for lease of county-owned property located along the Detroit Superior Bridge on West 25th Street in the city of Cleveland, permanent parcel numbers 00321-001 and 0032004 for the Irishtown Bend project for the period May 1, 2018 through April 30, 2043.
And this item will move to the May 15th council agenda for consideration for third reading adoption. Committee reports and consideration of resolutions for second reading adoption under suspension of rules. Could I have a motion to suspend the rules?
Mr. President, I move to suspend the rules.
Second.
Moved and seconded. Any discussion? All those in favor say aye.
Aye.
All those opposed, the ayes have it. Rules have been suspended.
Resolution number 2018-0082, authorizing an amendment to contract number CE 0800-729 with Primer Investment Company for lease of approximately 128 parking spaces located at 4209, 4213, and 4415 Euclid Avenue, Cleveland, for use by the Division of Children and Family Services for the period May 1, 2008 through April 30, 2018, to extend the time period to April 30, 2023, and for additional funds in the amount not to exceed $415,644.
Motion to adopt?
Moved and seconded.
Yes, and Mr. President, members of the Public Works Committee came before the members of the Public Works came before the Public Works Committee to explain the necessity of renting out these spaces so that they'll have places for the Division of Children and Family Services to park their vehicles during the day. So I would ask my colleagues for their support on this legislation, and it's a similar legislation for the 083 as well. Thank you.
All those in favor, say aye.
Aye.
All those opposed, the ayes have it. The resolution is adopted.
Resolution number 2018-0083, authorizing an amendment to contract number CE 0800-492 with Cleveland Commerce Center Incorporated for lease of approximately 125 parking spaces located at East 40th Street and Perkins Avenue, Cleveland, for use by the Division of Children and Family Services for the period May 1, 2008 through April 30, 2018, to extend the time period to April 30, 2023, and for additional funds in the amount not to exceed $367,617.
Motion to adopt?
Second.
Been moved and seconded, and I think the councilman explained it already. All those in favor say aye. Aye. All those opposed, the ayes have it. Resolution is adopted. We'll be skipping by the next one because we dealt with it earlier.
Resolution number 2018-0085, authorizing an amendment to an agreement with Cuyahoga County District Board of Health for acquisition and maintenance of a permanent facility for the period January 1, 2004 through December 31, 2023, to change the scope and the terms effective February 1, 2018, to extend the time period to December 31, 2038, and for additional funds in the amount not to exceed $4,789,750.
Move to adopt.
Second. Any discussion? Hearing none. All those in favor say aye.
Aye.
All those opposed, the ayes have it. The resolution is adopted.
Resolution number 2018-0086, making awards on requisition number 39869 to various providers, each in the amount not to exceed $300,000 for general engineering services for the period April 2nd, 2018 through April 21, 2021, as printed on the agenda.
Motion to adopt?
Second.
Been moved and seconded.
And, Mr. President, Department of Public Works came before the Public Works Committee to discuss these necessity of these contractors to do additional work. I believe it was in the area of sewers, I believe, improvements. I don't know if Director Dever is here to verify that.
All right. Director?
Good afternoon, members of council. Yes, these items are related to general engineering services, these two contracts for Chagrin Valley Engineering and HNTB. So that's general engineering for a myriad of uses to supplement our staff. We need additional personnel and expertise to assist on any of our projects, and that's the intent of these two engineering companies.
Thank you.
Questions of the director? Thank you. Hearing none. All those in favor, say aye. Aye. All those opposed, the ayes have it. The resolution is adopted.
Resolution number 2018-0087, authorizing an amendment to contract number CE 0600-807 with Maple Heights Commerce 2 for lease of space located at 21100 Southgate Park Boulevard, Maple Heights, for the period February 1, 2007 through January 31, 2017, to extend the time period to December 31, 2022, to change the terms effective February 1, 2017, and for additional funds in the amount not to exceed $394,263.10.
Motion to adopt?
Moved
And,
and seconded.
and Mr. President, if I could, with respect to this Southgate lease extension, this is for the Juvenile Court Probation Department, and the legislation was presented in the Public Works Committee on Wednesday, April 18th by the Department of Public Works. This amendment extends the lease to 12/31/2022, but the current lease expired January 31st, 2017. Naturally, most of the discussion at the Public Works Committee was around why the lease was 15 months late. One of the main reasons it was so late was that the property itself was sold during the summer last year, so the county had to negotiate with a new landlord, which brings us to today. During the committee, we learned that there was a lease payment to the new landlord in December of 2017 for rent from 2/1/17 to 12/31/17 without any Board of Control or council authorization. The current resolution includes language asking council to reaffirm this payment. The department has acknowledged that this wasn't the most ideal situation, but processed a payment without a Board of Control or council approval because the lease contained a holdover provision that obligated the county to pay for the lease since we occupied the space. The county's law department also provided an email that we should include the reaffirming language as part of the resolution. All of you were provided with that email from our staff. Although I very much dislike retroactively approving an unauthorized payment, given the totality of the circumstances, I understand why we're being asked to include the language from the department. I was assured by the administration that this won't be a normal practice moving forward, nor should it in 2018 be a practice in the county. My recommendation is to move forward with this legislation. I want to be clear that this recommendation does not condone what occurred, but acknowledges that we owed the landlord money from 15 months ago. I urge my colleagues to support this resolution. And you know, I don't proselytize much on the council floor, but I felt the urge to say what we said here to let everybody know where we stand on this issue. Thank you.
I have two
Councilwoman
questions.
Simon.
Two questions. One question is, how did this happen? I understand the circumstances you described or that were described to you, but there's a process that's in place for payments made with regard to the Board of Control or authorizing. How does that go through and maybe the system without anybody noticing that there was not proper authorization to make a payment? Number one question.
Could we stop right there and try to get that one answered?
Yes.
Okay, thank you. Could we have somebody come forward from the administration? This is, been trying to work through this particular piece for a while.
Once again, good afternoon, members of council. Michael Dever with Department of Public Works. Yes, this was not the ideal situation. As we had discussed in committee, the property, Trevor, I see you're here with us. The lease did terminate in February of 2017. The property at that time, there was two agencies that were within the juvenile court had space there. Also, the auto title was there. Auto title was looking for a new home at that time, and there was a tentative, they were looking at another location in Garfield Heights. That did not materialize. A new owner came in, ended up purchasing the property. This building itself, since we left and they had a tenant that was interested in the entire facility, they weren't sure if they wanted us to stay at the facility. Those negotiations went back and forth. As Councilman Tuma had said, there was a holdover provision within the current lease. Also, we had the budgeted dollars that were approved for 2017 to pay for that space. In December, we ended up processing a department voucher, and we ended up holding that check until we had the new landlord. The new landlord actually signed the document that he was going to lease to us for the next 5 years. We were not going to give him that check until that was taking place, or until he signed the document to give us that 5-year extension. If we were to take juvenile court out of the facility, it would have cost a relocation, a build-out cost. It made sense for us to stay at this facility. We believe we did have the provision. We believe we had authority for the holdover clause and the budgeted dollars to be able to at least pay for this retroactively. Once again, we did not give them the check until they issued or signed the 5-year extension to this, which took place in March, the end of March this year.
Councilwoman?
I just have a follow-up question. If you had the authority to do this, why do you need council approval at this point?
We are, basically, we're coming back to just affirm what had taken place there and to document what had happened. And that's why I'm before you today, is to explain what happened. And, you know, it's not the ideal situation, But as I said, I'm here to explain it.
My second question is, what is going to stop this from happening again? What safeguards? First of all, I don't understand how this happened, going through all the systems that we have in place, how this would happen. But going forward, you describe it as not being ideal. I'll adopt that description. How are we going to not have to address this again on the floor of council so this doesn't happen again? And maybe you can't answer that right now, but I don't want to see this personally coming to us with this situation going forward. And if we approve this, which I hear we don't even have to do, what's going to stop this from happening again and again?
I can commit to you that I will work towards to making sure a situation like this does not come before you again. I'll work with council staff to make sure that they're apprised if there is any type of situation like this. It's not an ideal situation, and I'm trying to rectify it.
Mr. McAleer, do you have anything to add to this?
Council President, I was just going to touch upon what the director said towards the end of his comments about Councilwoman Simon's question about how the process in terms of how the check was issued. It was issued based off a central services office voucher, which normally would be processed under an encumbrance voucher for a lease like this. But since the money was in the budget, in Public Works' budget, they were able to process it through an office voucher. So that's why it got through the fiscal department and accounts payable, because of the way it was paid and it was within the budget. So that's why I wanted to respond to your first question there.
Further questions, Councilman?
The chain of what took place just really bothers me, that you believe that we owe them the money. You had the check issued, but you were going to hold it, I'll use the word hostage, unless we got exactly what we wanted, which was a 5-year agreement?
No, that wasn't. We were negotiating the agreement. We had the agreement basically finalized towards the end of the year. Once they signed off on the agreement, it just took time to process it internally also. There were questions from internal departments here about the process.
I've negotiated business agreements before, and even though you think it's going to work, there can still be a glitch right at the end, and it does not satisfactory result. Would we still be holding that check today?
I don't believe so. I think we were starting to look down the path of going to another location. It would have taken some time to accommodate it for the juvenile court to move to another location. We did have that holdover clause within the document, the former agreement. So I suppose we'd still be there until we had another facility prepared or ready for us to move into.
So we owed the money whether you came to an agreement on a 5-year program or not.
That's correct.
I guess we're going to hear about a consumer affairs in just a few minutes, a piece of legislation. If I'm that landlord, I'm really feel as though the county was holding me hostage over that payment.
I don't know.
Do you have any disagreement on that?
I was trying to work out this arrangement the best way I could to keep it going forward.
Tough way to negotiate. And you have an email from the law director. Do we have a law director opinion that actually has come out in writing that says that everything is 100% in keeping with the law?
The council has the authority to take this action tonight as it's been requested with regard to affirming the previous payment. The law department does not disagree with the councilman's assessment here, is that this is not, that the appropriate way to have proceeded with this was to get either the Board of Control or council approval. I think that message has been delivered very clearly.
Yeah, you're giving us the opinion that we have the authority to retroactively fix the problem.
Yes.
Are you giving us the opinion that they had the authority to do what they did?
Yeah, I think that based on the various facts in here, what they outlined here, that if it's questioned, that it is defensible but it is not the way that our system is set up to proceed. The legal opinion is that based on our process, that they need to follow that process, to get the authorization for the payment. It is defensible, but I can't, it is not a recommended process at all.
Thank you.
All right. Any other comments, councilperson?
I appreciate
Councilman
my colleagues' comments on this, and this was some of the questions we had in the actual committee meeting, for sure. And I made it perfectly clear to the director, and the director acknowledged that moving forward, this procedure can't happen, and this council, this body, will not approve of this type of action moving forward. So better communication. We didn't even know about the situation. Maybe if we knew about the situation, this wouldn't even be as bitter a pill to swallow. But again, I appreciate my colleagues' comments, and I know the director understands where we stand on this. So thank you.
Councilman Miller?
I think it's not defensible. I don't know why you couldn't have just said that we handle thousands of contracts and we just made a mistake on this one and didn't do this right, and you have the authority to clean it up for us, and we ask for your help to do so.
Thank you. Clearly, the council is between a hard place and a rock, and I very much appreciate the work of the chairman of the committee in dealing with this awkward situation. I would want to support the chairman's proposal that we move this legislation forward, and that we try to take this as a lesson learned and have internal discussions about the future.
Thank you.
All those in favor of the legislation, please say aye.
Aye.
All those opposed? The ayes have it. The resolution is adopted. Consideration of resolutions for third reading adoption.
Resolution number 2018-0060, authorizing the county executive to accept dedication of land for Ethan Drive in Gates Village Subdivision Phase 1, located in Olmsted Township, as a public street with established setback lines, rights-of-way, and easements. Authorizing the county executive to accept dedication of easements for construction, maintenance, and operation of public facilities and appurtenances in Gates Village Subdivision Phase 1 to public use granted to the County of Cuyahoga and its corporate successors, and authorizing the county executive to execute the final plat in connection with said dedications.
To adopt.
Any discussion?
Mr. Chair, Mr. President, this was heard in the Planning Commission. We heard from the trustees of the township about this particular resolution, and they are in agreement with this, and any of the residents as well did not object to this. So we encourage support for this resolution.
All right. All those in favor say aye.
Aye.
All those opposed? The ayes have it. Resolution is adopted.
Resolution number 2018-0069, confirming the county executive's reappointment of the Honorable Bradley D. Sellers to serve on the Cuyahoga County Planning Commission, representing the Chagrin Southeast region for an unexpired term ending December 31, 2020.
Move to adopt.
Second.
Council President, as you know, Mayor Sellers is my personal mayor. He's been a valuable asset to the commission and is actively engaged with the department, and actually had a voice on the previous legislation, and would like to encourage my colleagues to continue to support his reappointment.
Any other discussion? All those in favor say aye. Aye. All those opposed? The ayes have it. The resolution is adopted.
Resolution number 2018-0072, making an award on requisition number 41694 to United Survey Incorporated in the amount not to exceed $2,955,017 for the 2018 sewer rehabilitation program in various county sewer districts for the period April 30, 2018 through April 30, 2020.
Motion to adopt.
Second.
Moved and seconded.
Mr. President, this came before Public Works Committee, and again, it's just part of the sewer rehab program, and I would ask for my colleagues' support on this so they can get to work on getting these sewers repaired.
All those in favor say aye. Aye. All those opposed, the ayes have it. The resolution is adopted.
Resolution number 2018-0075, amending the Cuyahoga County travel policy by updating the language and policies to conform with the current form of government.
Council President, we have a substitution today. The proposed.
Excuse me, Madam Chair, if
Oh,
you
I'm sorry.
will make a motion
So
and to
moved.
bring it up on the floor.
Thank
Been moved
you.
and seconded.
All right, we have a substitute today. The proposed substitute does three things. The first it does is incorporates the sheriff's recommendation regarding language around the daily duties of the sheriff deputies. The proposed substitute also includes the removal of the name of the software program that we currently use for travel policies and replaces it with a generic term in case the county ever changes software programs. And the final amendment deletes the management rights section that would allow the county executive to waive any section of the policy. This section was in the resolution twice. We removed it once during committee, but inadvertently left the second clause in the policy. And I respectfully move to propose the substitute as presented.
Any discussion on the proposed
Second
substitute?
on the substitute.
Been seconded. Any question on the proposed substitute? Hearing none, all those in favor of accepting the substitute, say aye.
Aye.
All those opposed? Ayes have it. The resolution is substituted. Any further discussion?
Just for the record, this new policy represents a significant update to the county's travel policies, which are being modified for the first time in over a decade. This item comes on the heels of the new HR Policy and Procedures Manual, and this counts, which we approved last month, and brings both policies into alignment. A few amendments made in the committee, in addition to the substitute we just adopted, most notably add additional requirements that the Board of Control approve travel involving airfare, international travel, out-of-state travel over $500, and expenses for educational programs above and beyond the basic job training. This updated policy makes county travel more accountable and transparent. This was much overdue as it has not been updated since 2007. This legislation also addresses issues noted from the state audit as well as our own internal audit department. And again, I urge my colleagues to support the travel policy. With that being said, I'll move to adopt. May have gotten ahead of myself there. Okay, all right.
Discussion?
I just want to say thank you to the chair and everybody who worked on this, president, everybody involved, and it's needed, and I wanted to add my name. Thank you.
All right. All those in favor of adopting the resolution on its merits as substituted, please say aye.
Aye.
All those opposed, the ayes have it. The resolution is adopted. Consideration of ordinances for third reading adoption.
Ordinance number 2018-0002, enacting Title 13, Chapter 1301 of the Cuyahoga County Code to establish the Cuyahoga County Consumer Protection Code, amending Section 202.16A7 of the Cuyahoga County Code to clarify the duties and responsibilities of the Department of Consumer Affairs Division of Consumer Protection.
Move to adopt.
Second.
Been moved and seconded. We had a pretty good discussion about this in the committee of the working committee earlier, but I'd like to ask Councilman Omer, hey, I don't know whether that is actually a good thing or not. But thank you, Mike King, for coming forward and give us maybe a little briefer explanation of the substitute. I think not all of it is necessary.
Sure. Thank you, Mr. President. Once again, this is a proposed substitute to one of two companion ordinances that would give the county the ability to enforce the state's Consumer Sales Practices Act, and through our County Executive and Director of Consumer Affairs. Again, this legislation has a proposed substitute attached to it, and this proposed substitute was developed after we received feedback from the auto dealers and the Greater Cleveland Partnership following committee, which is why this wasn't done in committee. So unless there are any further
questions on these substitutes to be, distinguished between one we expect to be put forward by the councilman? These are the ones put forward by the council. All those in favor of accepting the proposed substitute, please say aye.
We didn't have a motion to substitute. We should have.
All right, I'd like to
So I'll
make a
move.
motion to substitute the legislation. Could I have a second? A second. Now I'd like to ask for all the ayes for the proposed substitute. Aye. Thank you. Any nays? The ayes have it. The legislation is proposed. Thank you, our parliamentarian. Now, any further discussion? Jack, this is your shot.
Sure, thanks. I have an amendment, proposed ordinance, and you'll notice it says revised on the top. There was one word that was left out, and it was not through staff. It was my own fault as far as the one word, and that word is new. So it will read in the first sentence, new motor vehicles. So I just want to point that out to everybody that this is different than what we discussed earlier. In that it has the word new motor vehicles in there. With that, I propose the amendment to the ordinance to include the language as indicated in section B as revised.
Been moved and seconded. Any further discussion? Any questions about the proposed substitute? Sure, go ahead.
In addition, because I think we didn't have everybody, I don't believe, was in attendance at the time. First, I appreciate the legislation itself in the whole and its concepts, the idea and the background behind it, and what the purpose is intended. There are many areas in the area of law that are not going to be followed up by this method that it's currently being, or it's going to be voted on. There are procedures that exist to the benefit of our consumers, to the benefit of our clients, to the benefit of our patients, to benefit perhaps those even using the services of funeral homes and things of that nature that are not going to be touched and covered by this consumer area. I think that what we had is we also had a very personal and moving story, I think, from Mr. Marino that talked about his dealerships itself while he had moved into taking on a new dealership with Nissan with 25 complaints, all sitting in the AG. That would not, was not going to be allowed to move forward without the permission of the AG itself. I don't even know that we would have had that kind of leverage because what this meant, this kind of leverage was power that the AG could bring to the table. And so with that, this is not asking to treat this group any different than any other group. The same regulations, same procedures, same steps, same everything. The only thing is the speed to which the flow of the procedures themselves would flow. Instead of flowing as written, this would flow to the AG. These procedures have been in place since 1972. It's one of those off phrases we all use. If it ain't broke, why are we trying to fix this item? We're only talking about, I think we heard from the director, 5 to 8, perhaps maybe new car issues that have related at all out there. Her concern was used cars, and I apologize for not having the word new in the original language. And I believe that this is one of those areas that it would be very appropriate to use the existing structure that's been in place, been working for AGs for over 40 years, and why not use an effective working procedure? We do this in so many other areas, whether or not we're talking about in the law of medicine. I'm sure funeral homes and things of that nature all are going to be going through different procedures. Let's let this one work with the existing procedures that have been working fine.
I want to commend the councilman on the spirit in which this amendment is being put forward. I personally don't believe that it's necessary, but it's certainly worthy of discussion. And is there any further discussion? Councilman Jones and then Councilwoman Simon.
Thank you, Councilman. Chair, I guess my original question before that I asked previously, it still makes me wonder, why give up our responsibility? In other words, the constituents that elect us, if they have a concern, They certainly can go to the state, and it appears, I'm not questioning how effective that is. But we are, with this legislation, it sounds like we're saying they cannot come to us. That we have to, if they have a concern with the industry, they don't have a recourse at the county level with this legislation. They must go to the state. Why codify it at this level as opposed to allowing the directors and those to have the authority, the option to provide recourse and restitution, but make the decision at their level if it's better to allow it to move through the state process. To actually bind our hands and say we can't participate, and I imagine the industry, and it's been clearly said, they answered my question. Well, from the industry's perspective, they see it as, well, we're already dealing with our customers' concerns at the state level. Why should we as an industry have to respond not only to the state but to the county? But we're elected by the people. As you said earlier, we have to respond to the people. I still don't grasp why we would just abdicate our role and opportunity to serve the constituents if they came to us. That's the one concern I have.
Well, I think you heard loud and clear that in a dealership where the dealer transition of title within the state control, the state charter, that was going to be controlled. The AG was not even going to allow that to take place unless every one of those 25 complaints were resolved. And that was the power that office brought to that transaction. And it's very rare that you're going to find that many. But why not have the power of the higher office actually bringing that force down on, and Mr. Marino talked very specifically how that impacted and what it meant and how it was beneficial to all those 25 complaints to be resolved in totality as one total package before that dealership was going to be allowed to transfer under the state charter.
Well, the state certainly is the higher office, but we are the closer office to the constituents.
The 25, tell that to the 25 people that had their complete resolution all done at one time, because instead of handling 25 piecemeal, you had the ability to have all 25 of those transactions taking place because the AG saying that the title of that dealership is not going to transfer in the state law down at the Secretary of State's office without all those being completed. That's a big, that's a powerful message.
I think that was a very impressive example of how the current law worked well, and appreciate that, and appreciate the fine work of the Attorney General around that. I don't see how that really impacts on this legislation, however. I have Councilwoman Simon, and then Councilman Tuma, and then Councilwoman Baker.
Okay. The example with the Nissan dealership is a rare bird. It's an outlier. But I think if that ever came up again, our office would be able to work with the AG's office at the state level and consolidate and make sure that all 25 of these particular complaints would be able to be addressed in that way. But I think what's really important here is that I want my colleagues to understand that the AG's office at the state of Ohio has this program that's voluntary, and it's not mandated by the legislative body. There's a history of compliance and volunteer. It must be working well. But the important piece is this is only for new cars and not for used cars or leased cars. So even how this legislation amendment is presented to us, it talks about new motor vehicle dealers defined by ORC, which is the Ohio Revised Code. Those dealerships may include as well selling used cars or leased cars or cars other than brand new. So if we were to amend this, this would encompass dealerships that both sell, lease, both new and used. So if we exempt them, then they would be, we would leave out and carve out a whole segment of sales that include used cars. So I know you attempted to include only new car sales, but that's not what this does. So it would defeat the purpose of us having this tool, as Councilman Gallagher referred to it, or being a venue for our residents to come to have fast resolution. They would be precluded from coming to us if they had a case with a used car they purchased, if we use this amendment and pass it. So this doesn't even accomplish what you wanted to, just because of the ORC definition. So I'm not inclined to, there's no harm in this. In fact, it provides a fast resolution by way of mediation, a letter, a phone call that could promptly resolve something. And the AG is busy, and maybe this program is efficient. But we can't amend this because this would exclude all of the other car sales or leases. And that's a pretty important piece.
Okay, Councilwoman Baker?
Am I next?
I guess Mr. Tuma, I said, didn't I? Sorry.
Okay, all right. That's up to you, I don't care. You can go next.
You need to help me out here.
Stipulation, can we get our attorney to agree that this amendment is in fact what was stated?
I have ORC definition. Okay. New motor vehicle dealer means any person engaged in the business of selling at retail, displaying, or offering for sale of dealing in new motor vehicles pursuant to the contract or agreement. But there's no exclusivity to the definition that it's only new cars. I mean, they could have used cars too, but that's, so the definition says they are, I just read it. So you can address it. I'm not the law director.
It does say new vehicles. It was for the sale of new vehicles, though, right, when you read it?
It includes includes, but it's not mutually exclusive. I mean, they could be selling also on the lot, which I think if we heard testimony, which we're not, they could have used and new on their lot, and they would still be excluded by this amendment.
Okay, the clear intent of the amendment was to address new cars, and if that's the corrective action you're looking for, that you'd support it, I'd be more than happy to be very specific to make sure we cover that.
It's very difficult, just based on the reading. I understand that the nuance here, and that my recommendation would be that if it is the intent that other language be included in here to separate this from the Ohio Revised Code definition, just in an abundance of caution here, not having really drilled down deeply on it. I have no reason to dispute this, but there's enough in my mind here to say that if that's your intent, it's only new vehicles, you want to disassociate it from the statutory definition, make your own definition.
Okay. Well, if there's corrective action, corrective language that needs to be addressed, the intent was clearly to say that we're talking about those vehicles that are franchised, that are protected by the franchise relationship between, for example, Ford, General Motors, whatever that would be holding that franchise, which is not a used car. A used car does not hold a franchise relationship out there with the manufacturer.
Okay, thank you. Could we hear from Councilman Toma now?
Thank you. So my only comment is I'm not sure why we would refer this directly to the Attorney General. Like, even in common law practice, you start at the lowest level and work your way up the food chain. We get in an accident claim, we don't go right to the Supreme Court, we start at the local level first. So I'm not certain why we couldn't offer this service to our constituents at the local level, based on proximity and timing and everything else. Filing complaints with the Attorney General's office, I've dealt with them before on things, and I mean, it can take some time. And then it's just, as I think Councilman Gallagher correctly pointed out, it's just another tool that we have. And I don't want to take that out of our hands at the local level. We have enough. The state often, no offense to any former state representatives here, but the state oftentimes takes a lot of local control out of our hands, and I just think this is another tool to protect consumers. But I appreciate your comments, though. Thank you.
Councilwoman?
Thank you. Well, if there's anything I've learned here in the last year plus months, is that we are a county with limited resources
and unlimited needs. And if, we have local governments that use county services because there's just things that they can't do, and our county can serve them better than what our local governments can provide. We should really take advantage of the successful resources already in place through testimony earlier today by our Attorney General, with the very few complaints that do come before us, and use our limited county resources when needed that this amendment does allow. I guess my separation from what's being proposed and what this amendment allows us to do is that it allows us to use the resources if needed. The first place our consumer will go is to the Attorney General, which has already been in place, has been successful for years, and now we are changing that, not really because we have, at least I haven't heard any sound reasons why we should, but only because we can. And our constituents can have the best of both. They can go to the Attorney General that has been successful. If they find that for whatever reason it's not working for them, they can then come back to the county. And I don't see why we can't embrace that, save on those resources that are very limited, and allow those resources that are in place that have been successful to continue. And that's why I support this amendment, because I think it does allow for us to have our constituents have the best of both. And that's where I stand.
Thank you, Councilwoman. First, we've got Councilwoman Brown.
Thank you, Mr. President. So my question is, how are we defining success with the Attorney General? Because according to Mr. Marino's testimony, the AG only enforced this when there was a sale. It got up to 25, and it was only enforced because there was a sale, it sounded like. So how did it get up to 25? And if the dealership weren't going to be sold, then how are those consumers going to have their needs addressed? That is my concern. And if we can help them expedite that through this process by avoiding the language that has been proposed, I think that is to the benefit of this county.
If I may,
Councilwoman.
through testimony, when the direct question was asked, do you have an overwhelming or any concerns from new dealerships that there is an issue or concern that hasn't been handled by the Attorney General? And I believe the answer was no. We can do it quicker, we can do it faster, we're more accessible, we're more the answers back. But not that, yes, we are getting inundated with complaints that aren't being handled and our constituents in Cuyahoga County are not being served. That is why I take the position that if this is a successful program that we find complaints are limited, and if there are complaints are being handled, why do we want to change that practice only to cost us in the county more money to be the first in line instead of the second?
All right. Councilwoman Brown, sure.
To your point, if we're not being inundated, I don't think that it'll be a tremendous expense. It's just a matter of protocol. And again, given the example that was testimony by a dealer, in his own words, the AG enforced it only because there were a sale. What about those dealerships that are not going to be purchased or dealing with a sale? Our constituents should have an option other than the AG, and of course, being in having the ability to enforce what they should be practicing more efficiently without a sale being in place. That is my position. So I respect your opinion, though. Thank you, Councilwoman.
Thank you. And again, there is a second, this is AG's first, we are second. It's not that we're just saying, hope you can resolve your problems with the AG. It's only that we are second. And again, with the limited resources that we have here in the county, it just seems reasonable to me that we allow what's working to continue to work. And when it doesn't, for whatever reason, we are still here for you. Thank you.
Thank you. Councilman Schron and then Councilman Gallagher.
Thank you. Councilman Tuma said to handle it locally, but as we can all see what's going on with automobile brand new dealerships, they're crossing over county lines. They're not county specific. You can see it in dealerships that are already out in Mentor that come into Cuyahoga County goes into Mentor all the way, and these dealerships are now crossing over. So you're going to have no authority whatsoever to go to Lake County to handle an action that maybe is coming through a dealership. And I don't want to put names out there because I don't want to be casting aspersions that there's any of these dealerships that have any problems. But these dealers are no longer county specific. It used to be that one dealership, maybe that would be all that would be in a chain of dealers. But dealerships are now going into 8, 10, 15, 20 dealerships that are crossing over from one county to the next. A better resolution clearly is not to have it handled in the small local area as opposed to having it handled by the Attorney General who can cross over county borders.
Director, did you want to respond to the councilman? It's not necessary, but I was trying to read your, it seemed to me that you might have something to say. If not, fine.
We would have to refer, like, the way this is written, we can take Cuyahoga County cases. We can't take cases from outside. You're right. We would refer those, right? Because they're outside of our jurisdiction. But most of the vendors that we deal with, they cross all sorts of lines. We're only concerned about the residents of our county, protecting them. And we understand that there are bigger vendors. We understand there are Amazons, that there are, big box stores that operate forever. What we're concerned about is the residents who live in this particular county.
And I would say we are not a small
No, we're the
county.
largest in the state.
Councilman Gallagher.
Actually, this would be a question for the lobbyist, for Mr. Marino. Does this agreement with the Attorney General from 74 encompass the fact that if I buy a new car, I have to go to the Attorney General? I can't sue? You can come to the microphone, sir.
First and foremost, new car dealers sell new cars, used cars, and lease cars.
Right.
So
And my only question is, am I
question-
restricted from going
No.
to a local court?
Media, small claims.
Okay.
County, there's
Okay.
all
right.
everything that's available to you.
I'm just wondering
DBB.
why this argument isn't shifting towards attacking the courts as being overbearing and taking a bite out of that agreement with the Attorney General. I don't think, honestly, I think it's getting embarrassing to your point in that, again, I fall back on the harm. I haven't heard anything. I understand the concern from the dealers that maybe somebody will get a little out of control and push them to a point where, and we have problem customers, I understand that. But again, I guess that would be the biggest harm, and we're handling that?
I would say at this point, the AG's office where we have this plan put together is an elected official of the statewide.
Right.
The director is not. I mean, they're not an elected official.
And the judge is an elected official, and
Right, so you can go to the courts, you can go anywhere you
Right.
want. The issue is that this program's been in place for a number of years. I don't
Understood.
understand the harm. We are voluntarily participating in the program.
Sure.
We're bound by whatever decision is made, and the consumer's
Right.
not. Consumer can go to another agency, to the county, to the courts, they can go anywhere they want. If they don't like what result comes of the auto cap program in conjunction with the AG, they're free to go. And then the last thing is, the AG doesn't give everything to auto cap. They look at it.
Okay. Tell
and-
me what's the worst thing that could happen if we pass this legislation as is?
The worst thing that can happen is that we will have a concurrent investigation with the AG's office.
No. There's nothing in here that says you got to go to the AG first or second or third. There's nothing in here that says I can't go to court.
But the AG is not going to disclose to the county that there's a complaint filed and there is an investigation taking place while this division is doing the same thing.
Is that honestly the worst thing that could happen if this is passed?
It's another level and another group that is enforcing something that's already in place. You guys have said this a number of
and
times. The AG's
again, my question goes to the harm. Are you concerned of out-of-pocket costs with a consumer that is a little untoward, that won't let it go? Is that what we're dealing with here?
Multiple times, that
Okay.
can happen.
Okay.
And where we're coming with the
And
the
if we-
amendment is, if you go to the AG's office and the consumer is not satisfied, then come here. We have no issue, but we've had the process in place. We're pretty transparent. I mean, we have buildings, employees, we have a lot of dealerships in this county.
Has there been a problem with the local courts overstepping the Attorney General, or the Attorney General overstepping the local courts?
I wouldn't say that, because once it's
Okay,
in the
then
court
then
systems,
you really
you're out of
can't
the
say
AG.
that with this legislation.
Once you're out of the AG's office, you can file, you're not obligated to stay with your complaint with the AG, you can go to the court system.
I will tell you, I'm coming from a personal position here, and I won't tell you what it was, but I ended up going down to Columbus.
Mm-hmm.
The worst place in the world you want to be, if you're from Cuyahoga County, is in Columbus. Since I've been elected on this panel, and it's been 8 years, and maybe 8 years too long, I don't know. Columbus has taken close to $100 million out of Cuyahoga County, if not more. Actually, it's 9+ years. So my friends, my Republican friends in Columbus, haven't done this Republican any favors. So I'm not really, and I feel for you. You're doing your job. I understand that. But send a message that Gallagher doesn't like what's going on in Columbus, that we have people here, constituents of Cuyahoga County, that need to be represented. And if Columbus is worried about this costing too much or whatever, tell them to send me my $100 million and we'll call it even. And you know what I'm talking about, because you're a good lobbyist and you do your
Okay.
job.
Actually, you
Okay,
know what,
thank
Mr.
you.
Gallagher?
Listen.
I'm not a lobbyist, I'm the president of the
Yeah,
association.
thank you.
I am
Listen.
an attorney. Let me respond one thing.
Sure.
There are a lot of dealers in this county that process titles and do some of the things that are necessary. You were just talking about a location in Mayfield Heights? Is that what it was about? Was it title office?
Maple Heights.
Maple Heights? It's going to be pretty hard for us to continue that. We'll just, we're going to find other places to do business.
And legislation can be altered and amended.
Yep.
And if we run into concerns or questions that affect good dealerships, legitimate people that are doing good work, we're going to change it if this passes. I think you're putting the
All right,
cart before the
all right.
horse.
Okay, thank you. Thank you so much. And again, we appreciate the interaction by the Ohio Dealers Association. Again, we are going to let Councilwoman Simon, she's still got something
Just a couple.
that's bothering her.
Well, first, thank you.
But I just want to remind everybody of where we started, that we met with the Dealers Association. We have brought forward and passed 4 amendments in trying to be as responsible and responsive to them as we thought we should be. I think we've had pretty much exhausted this small part of this legislation, which again is not aimed at this industry in the first place. But I just don't believe that we should be carving out a special place for our good friends, highly respected industry that's very high profile, and again is not the target of this legislation. This is modest legislation. It's been well thought out. And with that, Councilwoman Simon.
So thank you very much to my colleague Gallagher asking about the worst case and the harm. And what I heard was two points, that there could be concurrent enforcement, but our president stated that we had an amendment tonight that precluded that from occurring. And the question came up, well, how would the county know if the AG's already working on something with regard to enforcing a claim? And I would be rest assured and sleep at night that the dealership itself would notify the county that the AG is already seeking enforcement with regard to any penalty. So we addressed that in the amendment, and as well as at talking about the elected official, we addressed that in the amendment because our consumer affairs director now, it's very clear that it would be the executive, the elected official. So the two things that seem to be the worst potential harm have been clearly addressed in the amendment. And I want to thank President Brady and Councilman Miller for doing that and sitting down with you to do that. But I want to state that Councilman Brown came up with the greatest example that there were 25 claims out there hanging, which were not addressed until the time of sale. I thought that was a great example of perhaps the efficiency of the AG that can't carry all these cases. And more importantly, our own consumer affairs, Cheryl Harris, director, states that I didn't hear her at all saying that she's going to be overwhelmed or our department can't cover all the claims that come in or that this would cause undue burden. In fact, what I'm hearing that these cases are far and few between. So I don't think the concern my other colleague has that somehow this is going to create a distraction from other important cases. So I think all these concerns are addressed. And Councilman Gallagher brought up lobbyists. I don't know if you are or you aren't, but I would ask you to look at the IG's, our ethics code that does require registering as a lobbyist. If you haven't, you probably need to look at that. And I'm consistent with bringing that up. I brought it in when we had lobbyists coming in for plastic, that it's important to look at that, but I don't know if you qualify or not.
Okay. All right. Well, thank you, everybody. Okay, that was good. It was good. The Councilman Sharon has moved a substitute amendment and an amendment, and Councilman Baker has seconded it. All those in favor of the substitute say aye.
Aye.
That's,
Is that a roll call?
no, Councilman Sharon's amendment. Okay, so there's two ayes. You have that? Two ayes. All those opposed say nay. Nay. Anybody left? All right. Well, unfortunately, Councilman, the amendment is defeated.
Part of life.
I know. I've been there.
Let me show you my book of words.
Now, help me keep this straight, either Councilman Miller or the clerk. All those in favor of adopting the ordinance on its merits as substituted by the council, say aye. Aye. All those opposed, the ayes have it. The legislation is adopted as substituted. Clerk, please read the companion piece.
Ordinance number 2018-0003, enacting Title 13, Chapter 1302 of the Cuyahoga County Code to establish the Cuyahoga County Weights and Measures Code.
Move to adopt. Been moved and seconded. Any discussion? All those in favor say aye. Aye. Any opposed? The ayes have it. All those legislation is adopted. Resolution is adopted. And let me say, to me, great debate. Everybody, I think, is very well intended. And this is the way it works. It's not always, smooth, but it works. And I want to thank the committee administration, and particularly the director, for her work over the time that she's been here, for putting forward this legislation. I also want to make sure to thank our staff, particularly Mike King, who worked on these amendments and helped us through this process. And so obviously, I'm pleased to see this legislation get to this point. Any miscellaneous committee reports, starting this direction?
Mr. President, my colleagues' finance and budget gets a bit of a break. We will not have a meeting before our next council meeting, but finance and budget will meet on Monday, May the 21st, at our regular 1 o'clock time, and that will be the first quarter budget update. That's a very important hearing. Thank you very much. All invited. Thank you.
All right.
Mr. President, thank you. Public Works is not quite as fortunate. We will be meeting at a regularly scheduled time next Wednesday at 10 a.m., and you're all welcome to join us as well. Thank you.
Anybody else?
Health and Human Services is Wednesday, May 2nd. We have two presentations. It's at 1 o'clock. Coming up following for the rest of the month, HHS first date for hearings with DCFS in regards to the policies and practices will start on May 16th. So a full month of HHS.
The Community Development Committee will meet April 30th at 10 a.m.
Education. Education, May 2nd at 3 o'clock.
All righty. under miscellaneous business, I just want to remind everybody we won't be meeting until after the primary election. The council unanimously put what has become issue 9 to renew the Health and Human Service levy on the ballot. That's the big issue for us. And I want to encourage everybody between now and the next 2 weeks in any way that they possibly can to help us pass this legislation, which we know we will only have to go back to the voters in November if we're not successful this primary election. With that said, anybody else? This council is adjourned.